So what happens when someone is charged with a crime and comes before the courts and has a mental condition?
There are three stages. The first is the question, is the person mentally unfit to stand trial? The second is, did the person have a mental impairment at the time of committing the offence? And the third and final question is, what should be done to such persons at the end of the court process by way of supervision or detention or treatment?
Okay, let's talk about the first stage of the process, unfitness to stand trial. What happens there?
Every person who comes before a court is presumed to be fit to stand trial. That is the starting point. And the question that is decided by the jury on evidence in open court is the person unfit to stand trial?
How does a jury decide if someone is unfit to stand trial?
There are a series of tests set out in the Act which determine that question. The tests include, can the accused person understand the charge that is brought against them? Can they understand the nature of the trial? Can they give instructions to their lawyer? An accused person, of course, does not need to understand every technical detail of a trial, but an accused person does need to understand what is going on.
What is the second stage of the process, the defence of mental impairment, all about?
This is a question of what was the mental condition of the accused at the time of the offence. Not at the time of trial, but at the time of the offence. And again, this question is determined in open court on evidence by a jury.
How does a jury decide whether a person is not guilty because of mental impairment?
There are two elements. The first is that mental impairment has a defined meaning in the law, and it includes serious mental conditions such as schizophrenia, intellectual disability, and acquired brain injury. It does not include effects of consumption of alcohol or drugs. The second step is whether, because of the mental impairment, at the time of committing the offence, the accused did not know what they were doing or did not know it was wrong. They're the two questions which are addressed by the jury.
What happens if a jury finds a person unfit to stand trial or not guilty because of mental impairment? Does the person go free?
The person does not go free. The person does not simply walk from the court. But with mental impairment, if the person is found unfit to stand trial or is found not guilty because of mental impairment, they are not able to simply to leave the court. Depending upon the nature of the charge, whether it might be murder or some relatively less charge, lengthy detention orders can be imposed upon accused people, which may involve being held in a secure psychiatric facility or hospital or other facility, or released, if the charges are much less, into a community if it is safe to do so, but for them to remain under supervision in the community and under compulsory treatment. It is all designed first to protect the community and also to seek to give proper medical treatment to persons who have medical conditions. In considering what orders to make, the court hears from the relevant parties, including victims and the families of victims, as well as the community considerations generally of public safety, which is central to the whole process. However, the court always seeks, within the boundaries of public safety, to enable persons with mental conditions to be given proper treatment and assistance.